Hi, it's Mike DelSignore, Massachusetts OUI Lawyer, and today I want to talk about an arrest at a roadblock or sobriety checkpoint. These are some of the most defensible and winnable cases for somebody who's been arrested for OUI. The reason why is there's no bad driving. So you pulled over just because they were doing a sobriety checkpoint. The state police, they have to comply with certain procedures to show the checkpoint was conducted properly. So you got a motion to potentially suppress and to say that the stop was invalid at the checkpoint, and then at trial you likely have a really good case. If there's no breathalyzer in the case, it's going to be a really difficult case to prove because there's typically no bad driving. Not only is there no bad driving, but they let you drive from the checkpoint to the screening area. So imagine I have the officer on the stand, question him, and basically I say to the officer, you trusted my client to drive from where you were, where other troopers were, into a screening area. And he drove perfectly, drove at the proper speed, parked the car safely. So I wouldn't ask him the question, well, you wouldn't have let him do that if you thought he was under the influence, because the officer might blow up the question and say, well, we have to. There's reasons why they kind of have to let them drive, but then you argue in closing where they have no chance to rebut it, or where they are left with just that testimony is that somebody under the influence, they would have gotten them out of the car. If they really thought it was strong indications of someone of being impaired when they're at the screening area, they certainly won't let them drive into the pit. So these are winnable cases, and there's other reasons too beyond that, but when you have no bad driving, it puts the government at a major disadvantage. The judge will instruct the jury that the government doesn't need evidence of unsafe and erratic driving to prove OUI. So somebody could be convicted of OUI without any evidence of bad driving, but they really want that evidence. It substantially weakens the case, and the rest of the case is going to have to be very strong for the government. So you're brought in, you go into the pit. Now, if you're polite, cooperative, respectful, the field sobriety test, in a case like this, as long as you don't make any major errors, there's not going to be enough evidence. And when I say a major error, I basically mean falling down. When I look at these field sobriety tests, I'm going to tell you that most cases I'll get a lot of information that's helpful to you. You might not see it in the report, but I'll see it when I read the report. The flaws, the gaps in the report, different clues they could have seen. 9-step walk and turn, there's 8 different things they're looking for. How you maintain balance in the instruction stance. Whether you start on time. You take 9 steps out. Are they heel to toe, straight line? Do you make a proper turn? Do you not stop and don't stop while you're not supposed to stop while walking? So all these little things they're supposed to see, and sometimes they don't see all of them, or they say they see miss heel to toe, but there's 18 steps. So most officers will acknowledge that if they only put it once, that it wasn't significant, that the other steps were likely heel to toe. So there are ways where we can minimize the testimony on these field sobriety tests, so they're not very harmful to the case. One leg stand, a lot of reports don't say how long you kept your foot up, and when that occurs, a lot of times I get the officer to say that you had it up for the full duration, 30 seconds. In other words, if you didn't have it up, that should be in the report. A lot of these reports don't contain those details. So don't make the mistake of just reading your report yourself, thinking you can't win the case, or having somebody review the report that really doesn't understand OUI defense, the clues on the field sobriety test. I have all the manuals. I've been to training after training on these things. It's what I do. It's what I'm known for. I go to court every day on these cases, so it's my passion. It's helping people charged with OUI cases. So no breath test, very good case. Probably should strongly consider taking the case to trial. Now, if there is a breath test, I would still suggest trying to fight it, because if you get that breath test knocked out, then there's likely very little evidence again. There are mistakes that can be made with the breath test. They're bringing it into a bat bus. They have to watch you for a period of time. So there's different things that could result in the test being excluded from evidence. So I would suggest strongly considering fighting a roadblock case. Now, if you want, you can resolve it. If you resolve it, you're looking at first OUI 45-day license loss, having to do an alcohol education program, and paying fines and fees. But if you have questions, what's the best decision for your case? Call, text anytime, 781-686-5924. My name is Mike DelSignore. I'm here to help. and you can reach me anytime at that number. You can reach out directly here, but feel free, just text, call, and I'll be glad to review your case.